Hi, on behalf of Gang Alternative Incorporated and the communications team, we'd like to welcome you to this brief presentation to commemorate Mental Health Awareness Month. Ms. Samantha Vassiana from Trial Lawyers of Florida, who is a proud partner and active partner with Gang Alternative Incorporated, will do a presentation to explain to us the differences between Baker Act and Marchman Act.
Thank you so much, Victoria. Good afternoon, everyone. My name again, like Victoria said, is Samantha Vassiana. I'm an attorney with the Trial Lawyers of Florida, and I'm really proud to be a partner with Gang Alternative. So it is Mental Health Awareness Month, and I think it's very important that people who are dealing with possible clients who may have mental health issues be aware of the differences between two very important laws that kind of govern mental health in Florida, the Baker Act and the Marchman Act. So without further ado, let's get into it. All right, let me give you some brief mental health stats, some brief mental health statistics that many of you probably are aware of, but just to tell you how important this topic is. So 5% of adults experience a mental illness in any 1 year. And that's equivalent to 43.8 million people in the United States suffering from mental illness. Very alarming statistics when you think about it. Almost half of the adults in the US will experience mental illness during their lifetime, and people with mental illness are arrested and sent to prison in disproportionate numbers. And of course, the type of work that you all do, you all are probably familiar with this last statistics where people are being sent to prison in disproportionate numbers because of mental illness. So the question that is often presented to lay people and those in the mental health profession and so forth is which law governs what? So Baker Act or Marchman Act, what's the difference? And so that's what we're going to be talking about today. The answer really is, while the two are often spoken about interchangeably by people who are not in the legal profession, both statutes are very distinct in how they operate, and the final result is completely different as well. First, let's talk about the Baker Act statute. That's Florida Statute 394, and I didn't put all the boring legal language in here. I didn't think this was, we would have enough time for that, but if you are bored and want to read something over during COVID-19, you can read Florida Statute 394. But in summary, Florida Baker's Act statute is the law that allows police, doctors, or mental health professionals to have someone committed for an involuntary 72-hour mental health evaluation. Both adults and children may be Baker Act. So what's the criteria then to Baker Act someone? And it's not a simple criteria. That actually is a pretty high standard to meet. So in order for someone to be Baker Acted under the statute, he or she must meet the following criteria. One, there has to be a reason to believe that he or she is mentally ill, right? That kind of makes sense. This means an impairment of the mental or emotional processes that allows a person to perceive or understand reality. And just a brief sort of note about that, just because someone has a mental illness, bipolar or any other illness, or there's not that necessary lack or impairment of the mental or emotional processes that prohibits them from understanding reality. There are people that are going through life every day on their medication, and they're able to function in life without any of their processes being inhibited. So here you clearly have to have someone who doesn't have the immediate ability to understand reality. And number two, because of his or her mental illness, the person has refused voluntary examination or is unable to determine whether examination is necessary. And three, without care or treatment, the person will cause serious harm, bodily harm to themselves or others in the near future, as evidenced by recent behavior. And that last part of the sentence is really important. And I'll give you just a brief example of something like that. A couple of weeks ago, I had someone call me to help their daughter who had gone to the neighbor's house and was cutting down the trees. And when the neighbor came out, the neighbor's like, "What are you doing?" And she said, "Well, you know, the trees are demonic, and they're talking to me, and they're threatening me." So the neighbor's like, "Okay, but you can't cut down my trees." So she went to take the tool from her that she was using to cut down the trees, and the young lady tried to attack her with the tool. Now that young lady suffers from schizophrenia and bipolar, and she has some other mental health illnesses. The reason that her mom was able to have the police Baker Act her is because the mental health illness and the proof of bodily harm to others and themselves was evidenced by recent behavior. So had this happened 3 weeks ago and mom's now trying to call the police to have her Baker acted, she would not have been able to do that. It's got to be an immediate type of behavior, last couple of hours, maybe even a day, but nothing more than that. So that's the criteria to Baker Act someone. The next question then is, who cannot be Baker acted? Well, people who are mentally retarded cannot be Baker acted. Developmentally retarded cannot be Baker acted. And intoxicated or substance abuse impairment cannot be Baker acted. You'll see later on why that is so. But if you're intoxicated or it's substance abuse, then you cannot be intoxicated. You cannot be incarcerated or Baker acted. That doesn't mean, though, that if you have a mental health illness and you're using substance abuse, that you can't use the Baker Act. All right, so who can invoke the Baker Act statute? If you remember a few slides ago, I gave you the list of the people who are able under the statute to Baker Act someone. That list includes law enforcement, physicians, mental health professionals, or judges. If you notice, it doesn't say anywhere in there about family and friends, because family, friends, etc., cannot invoke the Baker Act. It has to be by those specific people: law enforcement, physicians, mental health professionals, or judges. And so what you'll often see what happens is that a family member will call the police because their loved one is acting bizarre and threatening and is a danger to themselves or someone else. Or they may call the physician and say, they're having a mental break, and that kind of thing. The other way you can do it as a layperson is to request what's called an ex parte order from the court. And all that means is that you're getting an order from the court without the mentally ill person being there. The judge is doing that behind their back. And they're entitled later on to a hearing, but initially this is being done without their a person who's Baker acted can only be held involuntarily for 72 hours. And I think this is sometimes the most disheartening thing to family members, because they're like, what do you mean they can only be held for 72 hours? The court only has, not the court, but the facility only has the permission to hold them for 72 hours. And that 72 hours is to use to evaluate them to see if they are a danger to themselves or others. So what happens then if a person is not stabilized after the 72 hours? The person can be released outright if the doctors feel like they've been stabilized, or they're no longer a danger or a threat to themselves or others. A doctor can release them, or the doctor can refer them to an outpatient treatment facility within 72 hours of them being committed. They can be referred to a Baker Act receiving facility. But that's voluntarily. If they choose not to go, then there's nothing that can be done. Or if the person is not stabilized or cannot be stabilized within the 72 hours, the facility can ask for the person to consent to their commitment voluntarily. And sometimes that happens. Sometimes the person's now taking their medication or been given medication if they were never given any before, and they're starting to be lucid, and they understand that they need help and that they're a danger to themselves or others, and they may agree to their commitment. Again, the problem with that, though, is tomorrow morning they could also get up and say, you know what, I don't want to be here, and they get to walk out, and there's nothing that can be done. Or if they don't agree voluntarily and they are a danger and they're not stabilized, the administrator from the facility can file a petition through the circuit court for involuntary placement. So in the petition for involuntary placement, the facility has to list out why they think that this person is a continuing danger. The petition must be filed with a court of competent jurisdiction, and all that means is that it must be filed with a court that can actually hear that kind of hearing. The court must hold a hearing within 5 days. There's no exception to that. And then if the court finds that the person meets the criteria for continued involuntary commitment, the court can then commit the person up to a mental health facility for up to 6 months. And if that person's committed that way, they can't just walk out. That's under a court order. Also, and what we commonly see in my profession as a criminal defense attorney, and probably what many of you will see, is that if a person has a pending criminal charge that resulted in them also being Baker acted because, you know, they're doing something that violates the law, but they also have this mental illness, the prosecutor or the court can require that the person be involuntarily committed as part of any plea agreement. Plea agreement. So that's the Baker Act statute. So as you see, just to kind of summarize, the Baker Act statute focuses on mental illness only, doesn't care about substance abuse. Doesn't mean that if you're mentally ill, you may not also be abusing drugs, but the primary thrust of that statute, 394, is to deal with mentally ill people. In comparison to that, or in contrast to that, the Marchman Act then, also known as the Marchman Act, is the complete opposite. This is Florida statute number 397. Again, I didn't give you all the boring language, but if you want to go look it up, no problem. This provides for the involuntary or voluntary assessment and stabilization of a person who's allegedly abusing substances like drugs or alcohol, and it provides for treatment of substance abuse. What's the criteria then to Marchman Act someone? This is completely different. A family member can file a petition and have direct evidence of the person's inability to manage his or her substance abuse, or to show that the person has lost the power of self-control with respect to substance abuse, and that the person has inflicted or threatened or attempted to inflict or admitted to inflicting physical harm on himself or herself or another. So the family member can say that they have a really severe drug problem and they've threatened to harm someone, they have harmed someone, or they've threatened to harm themselves. And lastly, that person is in need of substance abuse services, and by reason of his or her substance abuse impairment, the judgment is so impaired that they're incapable of making a decision with regards to getting treatment. And usually this is the most severe cases. A lot of times you'll see parents of young adults, you know, between 18 and 24, who have a lot of severe substance abuse problem, and their parents may try to Marchman Act them. I saw a lot of this when the Flocka drug was really popular, and parents were just, you know, besides themselves trying to figure out what to do to help their children, and this is one way. So what does the parent or loved one needs to do? And this, I don't want to make it seem like the police can't Marchman Act you to, they can, but typically it's the family members. So what do they need to do? They file a petition for involuntary treatment in the county court where the person resides. So if the person lives in Miami, you can't file it in Palm Beach. You have to file it where the person lives. The Marchman Act requires that the petitioner, the person asking the court to Marchman Act their relative, be a spouse, a blood relative, or a group of 3 individuals with knowledge of the person's substance abuse. So 3 random strangers can't do it. It has to be somebody who knows about that person's substance abuse. But if you notice the difference between this and the Baker Act, a spouse, blood relative can do a Marchman Act. The spouse or relative or blood or group of individuals must believe and or have direct information that the user does not have power of self-control and is likely to harm himself or others. So just because your child will say, for example, is using drugs, if he's not a threat or she's not a threat to someone or themselves, you can't Marchman Act them, even though they have a drug problem or an alcohol problem. And you have to provide evidence that the person can't make rational decisions for him or herself. Because again, we all know that people that are functioning alcoholics, functioning drug addicts, they can make decisions, they operate in daily society, and so that type of person you would not be able to Baker Act. What happens after you file the petition? So the court sets a date for the hearing within 10 days, and it has to be heard pretty quickly after the petition's filed. The petition will be mailed, the petitioner, the person who's filing for getting their relative Marchman acted, the petitioner will be mailed information from the court regarding the hearing date. The respondent, the person who is being Marchman acted, will be served papers by law enforcement. They have to be served directly by law enforcement. And during the hearing, the court then evaluates what all the facts, all of the evidence that's been brought forward, and makes a decision. And if a person is to be Marchman acted, then the court will enter an order saying that they should be Marchman acted. Under the Marchman Act, a person can be held involuntarily for 5 days. This is another place where there's a big difference between the Baker Act and the Marchman Act. The Marchman Act is 5 days. The Baker Act, you can only be held for 3 days, 72 hours. So with the Marchman Act, then what happens if the person is not stabilized after 5 days? The court can order a person to involuntary inpatient treatment for up to 60 days. And again, the same thing as with the Baker Act. If the person has a criminal conviction, or a criminal case, I should say, not a conviction, but a criminal case where they're entering a plea agreement, the court or the prosecutor can make inpatient treatment longer. Could say, okay, you have to go to an inpatient facility for 6 months. And if you do not complete the 6 months, that is a violation of your probation, and you can end up in prison. So that's a good brief overview over between Baker Act and Marchman Act. If you have any other questions, as I said, I'm proud to partner with Gang Alternative. You can shoot me an email at Samantha@triallawyerspb, P like Peter, B like boy.com. Thank you everyone for listening. Enjoy the rest of your day.